The Board of Veterans' Appeals is a part of the Department of Veterans Affairs, but operates independently of VA regional offices. Its role is to provide impartial decisions on veterans' claims for benefits. Decisions by the BVA are legally binding and can set precedents for future claims. There are 5 steps in the VA board appeal process. The first step is submitting the notice of disagreement. To initiate a board appeal, you must file VA Form 10182, also called the Decision Review Request, Board Appeal, Notice of Disagreement. This must be filed within 1 year of the date on the VA decision letter. The second step is to choose a review lane. This can be found on Part 2 of the form. The board offers 3 appeal options, also called dockets, depending on how you want the case to be reviewed: direct review, no new evidence or hearing. The judge reviews the case based on the existing record. Evidence submission, submit new evidence within 90 days of filing the appeal, but no hearing is held. Hearing with a veterans law judge, VLJ, present your case in a personal hearing and submit new evidence during or within 90 days after the hearing. The veteran in this example has chosen to attend a hearing in Washington, D.C. We will go over how to decide which lane to choose later, but for now, let's move on to the other steps. Step 3 is the docket assignment. This is where your appeal will be placed in a waiting to be processed stage, based upon the lane chosen. Direct review lane is when no new evidence will be submitted and there will be no hearing. The judge reviews the case based on the existing record. This typically processes quicker. Evidence submission lane is when you want to submit new evidence within 90 days of filing the appeal, but no hearing is held. A hearing with a veterans law judge lane is where you will present your case in a personal hearing and submit new evidence during or within 90 days after the hearing. This lane typically takes longest. The fourth step is the board review. At this step, a veterans law judge reviews the appeal based on the evidence, testimony, and arguments presented. Then the veterans law judge issues a written decision, either granting, denying, or remanding the claim by sending it back to the VA for further action. The fifth step is the decision notification. The Board of Veterans' Appeals sends a decision letter explaining the outcome. If the appeal is denied, further options are available, such as filing a motion for reconsideration, appealing to the U.S. Court of Appeals for Veterans Claims, CAVC, or submitting a supplemental claim. Now that we've gone over the different lanes, let's discover which one might be best for you. There is no wrong or right lane. It all boils down to a few factors. Are you confident in the evidence you have already submitted to support your case to the judge, and you just want the judge to go over what is already on file, without going to court either by video or in person? If yes, then you can choose the direct review lane. This is best for cases where you believe the VA made an error in applying the law or evaluating evidence, but no new evidence is necessary. The judge reviews the same evidence used in the original decision, and it is typically faster than other options because no new evidence or hearing is involved. So if this sounds right for you, then choose the direct review lane. If you want to go ahead and submit the appeal but you know you will have new evidence within a couple of months, then you might want to choose the evidence submission lane. Remember, this evidence should be stronger than what was previously submitted. This is best for cases where you have new and relevant evidence to support your claim but do not require a hearing. You will submit evidence within 90 days of filing the notice of disagreement. The judge reviews the case and considers the new evidence. This is slower than direct review, but faster than a hearing request. Do you want to appear directly before the judge, either in person or virtually, to speak on your case? Then consider the hearing lane. This is best for cases where you want to personally present your case to a veterans law judge or where explaining the details in a hearing could make a difference. The Board of Veterans' Appeals will schedule a hearing, in person, virtual, or at the board's central office in Washington, D.C. You will be able to submit evidence during or within 90 days after the hearing. This typically is the slowest option due to scheduling and processing delays. There are three possible outcomes of a board appeal. It can be granted and the board agrees with your appeal and awards benefits. It can be denied. If the board disagrees and the claim remains denied, it can be remanded. When this happens, the board sends the case back to the VA regional office for further development or correction. This often happens when additional evidence or medical opinions are needed or the VA failed to properly process the claim. If your appeal was granted, VA will process your benefits to include any retroactive payments if applicable. If unfortunately you were denied, you still have options. But those options include starting over with a supplemental claim using new and relevant evidence. You can request reconsideration of the Board of Veterans' Appeals decision. Or, you can appealing to the U.S. Court of Appeals for Veterans Claims, CAVC, within 120 days. If you wish to appeal to the CAVC, you will be required to attend an actual court hearing in Washington, D.C. You can either represent yourself or hire a lawyer. The board appeal process is a critical step for many veterans in obtaining the benefits they deserve. With the right preparation and support, you can maximize your chances of a favorable outcome. Some key points to keep in mind are: read your decision letter carefully. Ensure you understand why the VA denied your claim and what evidence is needed for success. To prepare a strong case, you will need to focus on evidence that directly addresses the VA's reasons for denial. Legal arguments should align with VA laws and regulations. Seek assistance if you are not fully competent in going it alone. Work with a Veteran Service Officer, VSO, VA-accredited attorney, or claims agent to strengthen your case. Stay organized. Keep track of deadlines, correspondence, and submitted evidence. This is your case. The appeal process might have a long road ahead, but a man I love very much has a motto: never give up on something you are sure of. Some tips to help you along this journey: provide strong evidence. Whether submitting new evidence or relying on the existing record, ensure it directly supports your claim and addresses any deficiencies noted in the original decision. Request a hearing only if necessary. Hearings can delay your case significantly. Opt for a hearing only if you believe explaining your situation in person will make a significant difference. Understand legal standards. Familiarize yourself with VA laws and precedents applicable to your claim. Be patient. The BVA process can take time, particularly if you request a hearing. Staying informed and persistent is key. I wish you all the best.